One. Start. We are not satisfied that there is any substance in the grievances voiced by counsel. Stop. There was no vote faced on the part of the first defendant. Stop. Although it is true that basic defense was a denial of joint family ownership, it is seen that even in the trial court it had been considered and acted upon. Stop. In the appeal to the High Court, the present appellants did not state that they had been hit below the belt by the reliance on the admissions by the trial court in holding against them. Stop. Indeed, there is no suggestion in the judgment of the High Court that the appellants had been even contended about any prejudice to them, or that they had been denied an opportunity to explain the material so used against them. Stop. What is more, it is found that at no stage subsequent to the High Court decision, either in the memorandum of appeal appended to the application for a certificate or in the statement of the case in this court, has there been pointed ground of complaint about the unfair reliance on the admissions aforesaid to the detriment of the appellants. Stop. Under these circumstances, it is difficult to take the plea of prejudice seriously in, the absence of earlier articulation thereof. Stop. There is no merit even in the contention that because these three statements had not been put to the first plaintiff when he was in the witness box, or to the eighth defendant, although he had discreetly kept away from giving evidence, they cannot be used against him. Stop. Counsel drew our attention to section 145 of the Indian Evidence Act. Stop. There is a cardinal distinction between a party who is the author of a prior statement and a witness who is examined and is sought to be discredited by use of his prior statement. Stop. In the former case, an admission by a party is substantive evidence if it fulfills the requirements of section 21 of the Evidence Act, in the latter case, a prior statement is used to discredit the credibility of the witness and does not become substantive evidence. Stop. In the former, there is no necessary requirement of the statement containing the admission having to be put to the party because it is evidence. In the latter case, the court cannot be invited to disbelieve a witness on the strength of a prior contradictory statement unless it has been put to him as required by section 145 of the Evidence Act. Stop. This distinction has been clearly brought out in the ruling in Bharat Singh versus Bhagirathi. Stop. This court disposed of a similar argument with the following observations. Stop. Para. Admissions are substantive evidence by themselves in view of section 17 and 21 of the Indian Evidence Act, though they are not conclusive proof of the matters admitted. Stop. We are of opinion that the admissions duly proved are admissible evidence irrespective of whether the party making them appeared in the witness box or not, and whether that party, when appeared as witness, was confronted with those statements in case it made a statement contrary to those admissions. Stop. The purpose of contradicting the witness under section 145 of the Evidence Act is very much different from the purpose of proving the admission. Stop. Admission is substantive evidence of the fact admitted, while a previous statement used to contradict a witness does not become substantive evidence and merely serves the purpose of throwing doubt on the veracity of the witness. Stop. What weight is to be attached to an admission made by a party is a different matter from its use as admissible evidence. Stop. We, therefore, reach the conclusion that the appellant's arrival in this court has been an exercise in futility. Stop. The appeal must, therefore, fail and is hereby dismissed. Stop. There is some force in the submission that the first respondent had throughout in his pleadings set out a case against the joint family character of the properties, and it was only at the stage of the evidence that we fell back on the alternative case that has got him through. Stop. We, therefore, direct that the appellants shall be directed to pay only half the costs in this court. Stop.